When an organization hires a speaker or corporate trainer, they usually view the transaction in one very simple way. They are buying a service, paying a professional for their time, and paying them to talk. But this strictly transactional view ignores the underlying engine of that performance. Behind the spoken words lies a highly valuable, invisible asset: intellectual property. To understand the legal reality of the profession, we have to look at the educator as having a dual identity. The person standing on stage is the pedagogue, delivering a service, but the person who designed the presentation is the author, creating original works. Ignoring the author profile carries immense risks. Without recognizing this second identity, educators routinely lose control over their materials, watch helplessly as their work is recorded and redistributed, and forfeit optimized tax treatments. This is where Chapter 32 of Belgian copyright law steps in. It provides a strict legal framework designed specifically to separate the physical act of teaching from the assets used to teach. Failing to recognize the author hiding behind the pedagogue ultimately costs educators both their creative authority and their financial capital. The transmission of knowledge generates concrete products. Every session results in a physical inventory of slides, a written syllabus, and carefully devised exercise sets. Under the law, these materials are protected works the moment they bear the mark of the author's free and creative choices. The protection extends even further. A structured personal oral lecture is itself a protected work, independent of whether it is ever written down or recorded. An audience member filming a presentation and posting it online without permission is directly infringing on the speaker's copyright. The law does include a teaching exception, which allows educators to use fragments of other people's works in the classroom for illustration, but this exception never strips the creator of the course of their own exclusive rights. By stepping into a room and delivering a well-crafted lecture, a trainer automatically generates a portfolio of legally protected intellectual property. There is a widespread assumption that when an organization pays a trainer to deliver a session, they automatically acquire the rights to those teaching materials. The legal reality is exactly the opposite. If the trainer is self-employed, they retain all rights to their creations by default. Payment for the session transfers absolutely nothing. Even if the trainer is a direct employee of the organization, they still retain their copyright, unless an express written assignment clause is explicitly included in their employment contract. If an organization wants to reuse a trainer's slides, modify the syllabus, or have someone else teach the course, they must secure a formal written transfer. This takes two paths: assignment for permanent ownership, or licensing for a temporary rental. Licensing is best. It preserves moral rights and dictates limits on duration, territory, and authorized uses. Without a written transfer of rights in place, the organizing client is merely paying for a temporary experience. The trainer retains the permanent legacy. This civil distinction between the pedagogue and the author translates directly into tax strategy. Holding two identities requires structuring your invoicing to generate two distinct streams of remuneration. The first stream is the service fee. This covers the trainer's physical presence, the time spent, and the active facilitation of the room. It follows the standard, ordinary professional income tax regime. The second stream is the rights fee. This specifically compensates the trainer for licensing their original materials, the slides, the syllabus, the exercises, and it falls under a highly favorable copyright tax regime. When a client pays a lump sum training rate, that single invoice must be actively split to legally accommodate these two streams, separating the time spent teaching from the intellectual property being licensed. Actively dividing the invoice transforms what would otherwise be highly taxed professional labor into optimized intellectual property revenue. However, the boundary between the service and the rights must be strictly justified. You cannot arbitrarily inflate the copyright portion of the invoice just to maximize the tax benefit. Tax authorities demand a strict burden of proof. The trainer must demonstrate the existence of genuinely original works, provide a signed written contract, and show that the copyright fee is entirely commensurate with the true value of the materials being transferred. Since trainers rarely obtain formal arts work attestations, they typically access this regime through a secondary gateway, assigning rights to a third party for communication to the public. While this path loses certain flat-rate expense deductions under the 2026 rules, the tax separation itself remains an incredibly valuable tool. Securing this advantage requires 3 non-negotiable steps: document your materials, execute written contracts, and explicitly separate your physical presence from your property on the invoice. Separating the author from the pedagogue is the only way to protect both the integrity of your voice and the financial value of your work. This video provides general legal information, not personalized advice. Each situation requires its own dedicated analysis.